Assalamualaikum warahmatullahi ta'ala wabarakatuh. My name is Muhammad Zikru Hakim bin Ibrahim, nama metrik 1190325. Inshallah today we are Group 1 from KBA 8. We'll be present two different articles about the official secret act in Malaysia. So, first and foremost, let's go to the introduction. Freedom of media is the principle that communication and expression through various media should be considered a right to be exercised freely. Malaysia has many laws that restrict the function of media. The source of the restrictions can be found in Federal Constitution and many laws such as Sedition Act, Printing Presses and Publication Act, and others. So this first article is about Malaysian regulation regarding the issue of media freedom. Freedom in the press is valuable if people have full and true information on all matters of public interest. The government argues that it must restrict and control the press because Malaysia has a multicultural and multiracial and multi-religious country, has many sensitive considerations before press freedom could be implemented.
Assalamualaikum warahmatullahi wabarakatuh. My name is Nurul Izzati binti Abdul Halim. My metric number 1190251. I will continue with the media freedom. As we know, mass media includes radio, televisions, magazines, newspaper, and the internet. The author stated that the concept media freedom flourished in the 17th and 18th centuries in the United States and Europe. Media freedom is proven in studies by the Indian Press Commissions, for which freedom of the media is widely granted and various confusing interpretations, and this shows that the people understand the various meaning of media freedom. John Stuart Mill, one of the most numerous well-known philosophical supporters of the concept of freedom, he stressed the importance of freedom of opinion and speech as opposed to free function a modern democratic society where truth is upheld. In fact, the authors also agree that the press does indeed play an important role in enabling the individual's right to free press freedom, serve as a channel for disseminating information, because without the open communication of ideas and information, societies would remain in the darkness of ignorance. Okay, next, the background of Malaysian media. The author explained about the background of the media in Malaysia that in the 19th century, there were more than 40 English language newspapers appeared in the Malay Peninsula. Early English newspaper published by British colonial administrators, and the newspaper was driven to serve the British interests in Malaya and in particular to meet the business community. Malays published the Malay newspaper in the 1870s and 1900s. Early Malay journalists in Malaya was pioneered by non-Malay, in particular the Indian Muslims, the Arabs, and Baba Chinese. After that, the first Malay weekly, the Jawi Peranakan, was published in 1876 at Singapore. This followed by other publications at Singapore such as Sekolah Melayu Peranakan, Bintang Timur, and at Perak Sri Perak. Then, in the early decades of 20th century, the public sphere flourished when Malay nationalists utilized the newspaper as a channel for expressing Malay interests and opposition to British administration policies. The British finally granted Malay independence in 1957, and for the first time, freedom of the press was practiced in the 1951, 1952, and 1955 elections, and later was enriched in the Federal Constitution in 1957. The author also states that the guidelines and legislation of the Malaysian Constitution definitely restrict media freedom through a number of acts. Among them are the Internet Security Act, the Sedition Act, and the Printing Press and the Publication Act, plus certain media acts. The government used this restrictive law to limit function the role of the media industry in the country.
The federal constitution was talking about freedom of expression, and press is firmly assured by Part 2 of the federal constitution under Article 10, Clause 1, entitled Freedom of Speech, Assembly and Association. Article 10, Clause 1 allows that A. Every citizen has the right to freedom of speech and expression. B. All citizens have the right to assembly peaceably and without arms. C. All citizens have the right to form associations. However, although citizens have the right to freedom of expression and press, Section 2 of the article limits the right where Parliament may by law impose. Internal Security Act (ISA) was very synonym in Malaysian in Mahathir's era. In 1960, the government made a decision to create a new law called the Internal Security Act (ISA), with its main objective to eliminate the subversive threat and extinguish terrorism. Meanwhile, there are a few provisions under the ISA restricting people's freedom in Malaysia, mainly in terms of freedom of expression and the press. In this situation, the Prime Minister Mahathir Mohamad at that time has the power to determine whether an individual should be arrested under the ISA. Then impose restriction orders and following restrictions and conditions. In addition, the minister also has the power to ban the printing and circulation of publication if he finds that the publication ISA do something clash to the provisions like violence, counsel disobedience to the law, lead to the breach of the peace and prejudicial.
The Official Secret Act 1972. The Official Secret Act OSA 1972 Act R88 replaced the Malay States Official Secret Ordinance 1950 and was based on the British OSA 1911 and 1920. It was intended to curb and protect government secrets from falling into the hands of foreign agents or countries where this might be detrimental to national national security. However, the OSA was also seen to impose wide, largely unjustified restrictions of the rights to freedom of expression and press, and on the examination and discussion of issues of public interest by the political opposition. The Sedition Act 1948. The Sedition Act 1948. The Sedition Act SA 1948 Act R15 was implemented by the British colonial government in Malay in 1948. It was known as Sedition Ordinance 1948, designed to contain any risk to the colonial administration triggered by local people's dissatisfaction and initiated by Communist Party insurgency. Sedition acts also include organizing a public hearing or publishing an article which could create public disorder or instability, i.e., picketing, strikes, demonstrations, riots, and undermining the credibility of government bodies such as the judiciary and the police. After the events of 13 May 1969, the essay was tightened for the purpose of national stability. Thank you.
Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. My name is Muhammad Usamah bin Zulkifli. My metric number is 1192871, and I will continue our presentation to the next point, which is the Printing Presses and Publication Act 1984. In the first paragraph, the writer explained us about the Printing Presses and Publication Act, which is called PPPA 1984, which was based on Printing Presses Ordinance 1948 that have been used during emergency period caused by communists. Like the other laws, in this subtopic, the writer also stated about the section that related to the PPPA, and he also point us about the punishment and fines that the defendant need to solve if they found guilty for their problem. Next, we will move to the other laws that related to media information and communication, and first of all is Broadcasting Act. Broadcasting Act allow the Information Ministry to control and monitor all radio and television channels and stop the permit of any private companies which broadcasting information that contradict with government policies or again Malaysia values. Next point is the Control of Imported Publication Act 1959, which is tries to control and regulate the circulation and transmission of all foreign media publication within Malaysia, and bestows on the government that full power to ban foreign publication if the government believes that they constitute a risk to public order, morality, or the security of Malaysia. Next act is the Bernama Act. The Bernama Act, which established in 1967 as the government official news agency, he also mentioned about the amendment that allow Bernama to ignore the International Convention protecting freedom of information. And he also mentioned about the National Film Development Corporation Act, which is FINAS 1981, which was amended in 1984 in response to technological change that had taken place in the film industry. Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. My name is Muhammad Usamah bin Zulkifli. My metric number is 1192871. My team's next article review is Freedom of Information in Malaysia, A Long Arduous Journey to the Blue Yonder by Zalina Abdul Halim in years 2000. First of all, the introduction. The introduction talk about the main intention of this paper, which is about freedom of information in Malaysia and the extent of availability of information to the public. The writer also mentioned that this paper will give an overview of the position of the major laws relating to access to information and the state practice pertaining to information on the operation of administrative bodies and government agencies. After the introduction, the writer highlights us about what is the information. In the first point in this paper, the writer mentioned about the definition and the importance of information in a political, legal, and economic scenario field. The writer mentioned in this point about the usefulness, the real information, in order to expose a sham, declare legal right, and determine profit and loss. There are something to be achieved quickly and before everyone else does. And lastly, the writer mentioned about the difficulty to gain information, which can be expensive, inaccessible, inaccurate, incomprehensible, especially if it is information held by the government. Next, we will move to the main body of this paper, and the first part is Malaysia. First of all, the writer explained to the audience and the reader about Malaysia itself, about the states, about the religions, about the races, and so on. She also mentioned that Malaysia is inherited from the British, the Westminster parliamentary system of government and the common law legal system. The constitutional monarch is the YDPA, which is Yang di-Pertuan Agong, whose position is rotated among the 9 rulers from the Malay kingdoms. Also, she mentioned about the Malaysian Federal Constitution that provides a bicameral legislature consisting of the Dewan Rakyat, which is lower house, and the Dewan Negara, which is upper house. Next, we will move to the second part of the main content for this paper, which is the legal regime. First of all is Federal Constitution. The first subpart in this second part is the Federal Constitution. The writer highlighted in this subpart about the Malaysian Federal Constitution that provides the community freedom of speech, subject to certain restrictions including security reasons, friendly relation with other states, morality, public order, and incitement to commit offences. It also stated that freedom of information is inextricably linked and intertwined with the freedom of speech and expression.
Evidence Act 1950. Evidence Act government information is also protected in court proceedings, whereby Section 123 of the Evidence Act 1950 prevents the production of any unpublished official record or information therein relating to affairs of state without the permission of the head of the department. The public interest is also a ground to raise in seeking non-disclosure of government secret of communications. In this country, the court in an inquiry of all available evidence decides objection as to protection as well as admissibility contemplated in sections 123 and 162 of the Evidence Act. The Printing Process 1984. The Printing Process and Publication Act (PPPA) is another beautiful mess of right turns and dead ends for the media organization, which inhibits the dissemination of information and participation in discussion of important public interest issues. In that it is unfortunate that the Malaysia Supreme Court chose a literal interpretation when faced with a constitutional challenge to the validity of Section 8A of the PPPA. Secret Act 1972. Being a former colony of the Britain, Malaysia is blessed with the genetic makeup of the British bureaucratic stiffness and secrecy of government working. So Section 8 of the Official Secret Act (OSA) inherited the infamous right of criminal offences from Section 2 of the UK Official Secret Act 1911. There were 2 amendments made to the Act in 1984 and in 1986. Essentially, the section concerns official secrets, secret official code words, countersign or password. The OSA protects official information and documents irrespective of its contents or whether or not it is of a sensitive nature. The power to classify and document our information as an official secret is confined to the minister and senior government officials.
Next, the Seditions Act 1948. The significant point regarding freedom of information under this legislation is the insertion of an innovative definition of seditious tendency in the aftermath of May 30 racial riots, which had also severely restricted the access to information in Parliament. The Constitution provision seriously affect the quality of debate and discussion in Parliament, hindering the public access to information via their elected representatives. Police Act 1967. The public is also hindered from obtaining information when assemblies or gatherings are restricted and prevented from being held. Section 27 gives the police power to regulate conduct in public places to prevent public order and security, including assemblies, meetings, and processions. If permits are not obtained or a license condition is not complied with, offence of unlawful assembly under Section 27(8) will be committed. Commission of Inquiry Act 1950. Commission of Inquiry designed to lead inquiries on have the capacity to prohibit the public and the press from their proceedings. The lack of information relayed to the public upon discoveries of abuses, scandals, and corruptions in words when there are not any commission of inquiry set up. Next, the Local Government Act 1976. This legislation provides for the establishments, functions, powers, and duties of the local government body having responsibility to manage the public amenities within a particular district or town area. There are some provisions that allow the public access to information on their operations, therefore allowing public scrutiny on their actions and decisions.
Okay, next, Defamation Act 1957. In Defamation Act, the use of uncontrolled defamatory actions and excessive damage to restrict media reporting on issues of public interest affecting public privacy can be construed as restricting access to information. Okay, next, practice of freedom of information, reform of the civil service. The writer states that the government has been implemented the Malaysian Public Service Link (MCSL). This MCSL can help users obtain government information and promote public domain database as well as a network of government agencies. In addition to CSL, government agencies and state government websites are also provided to provide information and opportunities for public feedback. Okay, next, tender process environmental impact assessment reports. Writer mentioned that one of the hidden secrets in Malaysia is the danger of major project and supply contract. Then, with respect to the need to make an environmental impact assessment (EIA) report before commencing major activities which affect the environment, community input and views on the proposed project are often set aside. The project remains underway even though the EIA report has not been improved. Worse yet, it has the potential to be an environmental disaster and ecological destruction. Okay, next, local authorities meetings. The writer also states that many people are unaware of the real facts about environmental issues such as discriminate dumping of toxic waste. After that, the community has no mechanism that makes it possible to ask, complain, and seek compensation from the authorities.
Legislatives, which known as make the law legislative proceedings, had a lot of discussions, but not just based on a voice group of people, but any case. Depends on the representatives and the issue that they want. Besides, it was implemented through several methods like doctrine of collective and ministerial responsibility, question time in parliament and state assemblies, debates and motions, committees of the legislature and constituency, work by members of parliament and assemblymen. To conclude, legislative proceedings was about 90% of voice of people and 10% representatives, because at the end of the day, the representative will talk on the issue and maybe will be add on from the representative. Recent development nowadays explain mainstream media is a propaganda machine for the ruling government and playing a main role, and shows that political parties belonging to the media. Besides that, recent development shows independent viewpoints content nowadays about Malaysia in the websites such as malaysiakini.com and harakadaily.com, which known as very popular site and give a breath of fresh news to the hungry public. At the end of the day, it was reported in the media that the government would look into strengthening the security procedures of public documents and the like in the wake of recent cases involving highly classified papers. The conclusion, many of the countries, especially in the Europe, have moved towards a jurisprudence of whether access to information, yet Ayer explains that the rationale for this is that he who seeks information must have the right to secure it when he wants it, not at the whim or will or time of a minion of government. This highlight in Article 19, Clause 2 of the Covenant on Civil and Political Rights that everyone shall have the right to freedom of expression. Even though informed decision cannot be made without adequate information, transparency and accountability is still lacked and felt by the nation. Last but not least, existing laws need to be reviewed and major overhauls need to be done on the solid or secrecy mentality of these laws and within the civil service, and we ourselves should self-censor and limit the flow of information, even to ourselves. Thank you.